So I am Don Verrilli, and I am the Solicitor General. So, the question of what this office does and whether it represents the interests of the administration or the interests of the United States is really a complicated one. I think the place to start is to think about the touchstone for our decision making. And the touchstone for our decision making in this office is the long-term interests of the United States. We evaluate everything we do in terms of our best assessment of the long-term interests of the United States. And in the vast majority of our work, the long-term interest of the United States just doesn't vary from administration to administration. We defend federal agencies when their actions are challenged. We seek to uphold convictions that have been obtained by federal prosecutors under the federal criminal law. We defend federal officials when they've been sued for damages. And we do that with consistency from administration to administration. There are some number of cases, small number of cases, in which judgments may differ about what the long-term interest of the United States is from administration to administration, based on legal policy judgments that I think everyone would consider are legitimate legal policy judgments for an administration to make. For example, some administrations enforce the environmental laws and antitrust laws more robustly than others. We have an example of that just from last term, the Federal Trade Commission against Actavis case. That was a case in which the question was whether the antitrust laws ought to apply to these agreements called pay-for-delay agreements between brand name pharmaceutical companies and generics to settle patent suits. Now, previously, the executive branch had taken the position and articulated it in courts, including the Supreme Court, that those kinds of agreements to settle patent suits should generally be immune from antitrust litigation. This administration reached a different legal policy judgment that thought that those kinds of agreements tended to harm consumers and ought to be subject to more rigorous antitrust scrutiny. So we took that position and advanced it in front of the court. So there are situations like that in which you can see some variation in legal policy judgments, but I think the best way to think about those is those are just different judgments about what we think is in the long-term interest of the United States. And we make judgments on those bases. One basis we never make a judgment on, and I think this has historically been true now, and I think it's just a rock-solid principle of the office, is that partisan considerations, partisan political considerations just don't play any role in any judgment we make. And even with that touchstone in mind, that, it is sometimes the case that the judgments that this office makes and that the department makes about what position the United States should take in a case are not identical to the position that the president might want to take. There are a couple of historical examples of that. One is, and they're not exactly examples of conflict, but they are examples of disagreement that have to get worked out. And one well-known example goes back to the 1960s when this office was charged with the responsibility of defending the constitutionality of the Civil Rights Act of 1964. And Archibald Cox, legendary Solicitor General, was faced with a choice of what constitutional theory to advocate in defense of the constitutionality of the law. He could have advocated the position that it was a law that was justified as an exercise of Congress's power under Section 5 of the 14th Amendment to enforce the guarantees of the 14th Amendment. He could have decided to justify the law as an exercise of Congress's commerce power. The President Kennedy at the time, very much wanted the Solicitor General to argue that it was an exercise of Congress's power under Section 5 of the 14th Amendment. And the Attorney General, I think, wanted the same thing. But Solicitor General Cox resisted that judgment, thought the better legal judgment, the better way to win the case, and the way to approach the case most consistent with the overall institutional values of the United States and of this office was to argue the Commerce Clause rationale and not the 14th Amendment rationale, in part because the 14th Amendment rationale would have required the court to overrule one of its 19th century precedents, and the Solicitor General thought that would be an ill-advised thing to take. So there was disagreement there, but resolved in that way. In the Board of Regents against Bakke in the 1970s, there was also a well-known disagreement between this office and the White House about what position the United States ought to take on the question of the constitutionality of affirmative action programs in public higher education. And that, again, worked itself out through a process of engagement between the White House and the Department of Justice. But those are a couple of historical examples. So it does happen from time to time. One thing we do have to make judgments about is the question of whether to participate as amicus curiae, as friend of the court, in cases where we're not a party. I think the best way to understand that is for me to talk about the process that we use to make those decisions. It's a very elaborate process. It will begin, if the court has granted cert in a case, the process will begin with a lawyer in the office, an assistant, sending out a request for views to the various parts of the executive branch, any agency or department that the assistant thinks might have an interest in the legal issue that the case presents, and then to any division within the Justice Department that the assistant thinks may have an interest. And then anybody who gets a request for views, who wants to submit views, will prepare a memo, and those memos tend to be quite elaborate, laying out a justification for why it would be in the interest of the United States to participate in the case, what position we should take, why we should take it, how we should argue it. And we can often get memos from different executive branch agencies and different divisions within the department that disagree with each other. Some saying we should go in, some saying we shouldn't, some saying we should go in on one side, some saying we should go in on the other side, providing reasons for that. The assistant will gather up all those views and prepare a comprehensive memo and make a recommendation. And that recommendation will then go to the deputy in whose area of responsibility the case is. That deputy will then make a recommendation, and then that packet will come to me, to the Solicitor General, for a decision about what position the United States should take. As part of that process, we almost invariably, if not invariably, invite in the lawyers for the parties to the case, always the lawyers for both sides, to allow them to seek to persuade us that we ought to be on their side in the case. Of course, the judgment we're making in that situation is not a judgment about whether we like one side better than the other, but a judgment about where the interests of the United States lie. And the interests of the United States lie in alignment with the petitioner or with the respondent or somewhere in between. And so we make our evaluation based on what's in the interest of the United States. And so what goes into the question of what's in the interest of the United States? Well, does a case involve, say, even though it's between private parties, does a case involve the interpretation of a federal statute that might well matter to federal regulatory agencies? Does the case call into question a practice of a state government, say, or a local government that the United States government also engages in and therefore would have an interest in seeking to uphold? Does the case involve calling into question a doctrine or an enforcement tool that a United States government agency uses with regularity to promote federal interests? Questions of that nature. So it's always about what's in the interest of the United States, judged from those kinds of perspectives. And one example of that would be the Town of Greece case that's before the court this term, where we made a judgment, as our brief explains at the beginning of the brief, that the question of legislative prayer, which is at issue in the setting of a town council meeting in the Town of Greece, is one that could implicate the constitutionality of the legislative prayer that has marked the beginning of every meeting session of Congress since the founding, and that we had a responsibility in the interest of the United States to ensure that we do what we can to protect the legitimacy and constitutionality of that long-established practice of the Congress.